This discussion is about the housing crisis, and it's important because
This discussion is about the housing crisis, and it's important because
This discussion is about the housing crisis, and it's important because
This discussion is about the housing crisis, and it's important because
This discussion is about the housing crisis, and it is important because one of the things that we try to do, especially in the courthouse as judges, is to ensure that people have an opportunity to come to court to be heard.
tenants need to be aware of the laws that are protecting them as well as their rights.
it's important that tenants know their rights, and that can sometimes be the difference between the tenant being able to stay in the property and the tenant not being able to be in the property.
landlords that are not actually familiar with being landlords.
because there are lots of people who are being put out of their houses who need someplace to live. The need for housing is in fact a right, and you should have a place to live.
Hello, I'm Russ Wigginton, President of the National Civil Rights Museum. I'll be serving as the moderator for today's panel discussion on housing issues in Memphis, Tennessee. The title of the panel is Seeking Common Ground, Perspective from Landlords, Tenants, and the People Who Serve Them. The panel is presented by 901 Legal Connect, an online legal one-stop portal provided by the Memphis Bar Foundation in partnership with Community Legal Center and Memphis Area Legal Services. 901 Legal Connect's primary purpose is to connect low-income residents in Fayette, Lauderdale, Shelby, and Tipton counties to free to low-cost legal service providers. 901 Legal Connect also serves as a resource for legal issues. Numerous residents have been adversely affected by the pandemic, particularly in the area of housing. Tenants and their landlords are struggling to navigate the eviction process under unprecedented circumstances. In response, 901 Legal Connect, in collaboration with Memphis Area Legal Services and the National Civil Rights Museum, are presenting this panel discussion to address challenges faced by landlords and tenants. The goal of the panel discussion is to present a clear picture of what tenants, particularly those without other housing options, are facing, while at the same time voicing the concerns of landlords. The National Civil Rights Museum serves as an ideal backdrop for this discussion because housing is indeed a civil right. At this time, I would like to introduce you to our panelists who will give brief introductions of themselves. Judge Betty Thomas Moore, General Sessions Judge in Division 5, Attorney Ben Sissom of Sissom Law, representing the landlord's perspective, Landlord Alan Mathis, Attorney Robin Warren, Managing Attorney of the Fair Housing Center for Memphis Area Legal Services, representing the tenant's perspective, and Tenant Davita Ricks. Judge Moore.
Good afternoon, everyone. Thank you so much for having me here. I am honored to be a part of this distinguished panel. I am Judge Betty Thomas Moore, and I am a judge in Division 5 of General Sessions Civil Court. I have been on the bench for almost 24 years, and in our General Sessions Court, we're here because we're dealing with evictions, and that is a major part of what we do in that court, amongst other things like debt collection, car accident cases, any kind of case that is valued at $25,000 or less. I agree when you say that this landlord-tenant issue is such I call it sometimes a superhuman type of situation because it is a situation that never has happened before. And so I'm honored to be here in order to kind of let folk know what we do in the courts. Again, thank you for having me.
Thank you. Attorney Sisman.
I'm an attorney who, in these cases, mostly represents landlords, though I do consumer bankruptcy work. And so I appear before Judge Moore all the time and have cases with Mr. Warren on representing the tenant on the other side. And I'm a landlord myself.
Mr. Mathis.
Thank you for having me. I'm glad to be here and honored to give the landlord's perspective. I am a past entrepreneur and landlord and locally here in Memphis. So,
Thank you. Attorney Warren.
Yes, I'm Robin Warren. I am the managing attorney of the Fair Housing Center at Memphis Area Legal Services. I've been doing that since 2021. I started off in fair housing. I mainly focused on unlawful ousters and property tax redemption, excess proceeds motions. I am delighted to be here, and I hope that we gain a new perspective from all points of view.
Thank you. Miss Ricks.
My name is Davita Ricks, and I am a tenant who juggled the hardships of the COVID-19 pandemic. And I'm honored to be here because I feel like this would be a very eye-opening experience to get an understanding of what tenants go through. And going through this process and the learning, advantages that I gained. I learned a lot of information through this situation, so.
Thank you, Ms. Ricks. And with that, would like to ask the first question to Ms. Ricks. Ms. Ricks, what is the biggest challenge you have faced as a renter?
Since the pandemic, I think the biggest challenge was maintaining the finances, because when COVID shut down everything, it affected my household. So my home was a 2-income household, and it was necessary for everyone, for both of us, my husband and myself, to work to maintain our family. When COVID happened, it caused my husband's job to go. His position was discontinued. So we were home, and then I worked, but I was underemployed. And so though I worked in a professional field for a local agency in healthcare, being underemployed didn't allow me to maintain our bills on a regular for what was necessary.
Sure. And as a follow-up question, Ms. Ricks, obviously the ability to pay your rent on time is important. What are some of the an example of a lesser challenge? For example, have you ever been required through a lease to make your own repairs or be responsible for your repairs? Something that's may not be thought about in the same way as paying your rent, but some other dimensions to challenges you may have faced.
Yes. So making repairs is a challenge that face, or even just regular life emergencies. So when you're dealing with hardship situations, just a regular car tire being flat becomes even more of a crisis.
Sure, thank you. I'd like to turn to Attorney Warren for the next question. Attorney Warren, how can a tenant get a landlord to make repairs, and what repairs is the landlord obligated to make?
I wouldn't necessarily say that you can make the landlord perform the repairs. We always advise our clients to start off with code enforcement, because generally code enforcement will cite the landlord, and we'll take them to environmental court, if they don't complete the repairs within the time that code enforcement gives to the landlord. Now, I would say that generally the landlord has an obligation to keep the premises in a fit and habitable condition. And I would say for the tenant to refer to the rental agreement, because I have seen rental agreements that require the tenant to pay for repairs $200 and under. And that can be problematic, because sometimes I've seen where landlords have separated the repairs in such a way, like if the AC is not working, then they separate the repairs in a way that makes each repair $200. I've seen that done. So I would say the first important step into determining what your obligations are is to know what's in the rental agreement.
Sure, thank you. Attorney Sisman, if a landlord fears his property is being damaged by the tenant, what rights does the landlord have?
Well, if you are afraid that your landlord or your tenant is damaging the property, then you would want to go check. And if you see that they are, then you would want to take steps to evict that tenant. You just like you can't, as Robin says, you can't make the landlord fix things, you can't make the tenant do right. If the tenant's going to do damage, they're going to do damage. And it's not unheard of for tenants to deliberately damage property on their way out the door.
Sure. Thank you. Mr. Mathis, according to the Urban Institute, there are 8 million independent landlords in the United States. As an independent landlord, what is the overall impact of prolonged rent delinquencies?
Well, the ultimate impact has a direct effect on the economy and the outcomes because cash flow rules the world, basically. When landlords do not get the income, the rent, it just doesn't affect that one tenant. That landlord then becomes in jeopardy because their debt to ratios may vary. Each landlord, there's no blue book to be a landlord. So each landlord debt to ratio may run from 0 to 100.
Mm-hmm. Great, thank you. And as a follow-up, have prolonged rent delinquencies led you to consider selling any of your properties?
Yes. Mm-hmm.
Could you elaborate?
Absolutely. I sold a property just last week, and it was because of debt. The units we do have lots of equity in, and now property values have skyrocketed. Lots of landlords are getting rid of properties that are less desirable to inject the money back into other debts.
Sure. Attorney Sisman, how long is a landlord required to allow a non-paying or partial paying tenant to remain in a property?
Well, if the landlord has a written lease and the written lease says that they don't have to give any notice, they can move to evict the tenant within 5 days after the beginning of the rental term. So by the 5th of the month, say. Right now the courts are a little bit backed up because of COVID, but you can get to court if everything's running the way it should be within about 30 days.
Okay.
You don't have to wait. Now, if a landlord doesn't have a lease, then it would take longer because you have to give notice, but otherwise, almost immediately.
Okay. Ms. Ricks, Tennessee's Uniform Residential Landlord Tenant Act allows the tenant to waive notice of non-payment of rent. Did you know that in most leases, your landlord does not have to give you any written notice before filing an eviction for non-payment of rent?
That was something I learned through this process. I think one of the bigger issues for tenants is the knowledge base, knowing what laws are out there. So I've learned a lot through this process about the laws that are there to help tenants. But prior to this, I would have never known.
Thank you. Attorney Warren, how much notice does a tenant get prior to getting evicted?
Well, I just want to piggyback on what Attorney Sisman and Ms. Ricks were saying. Most lease agreements, they waive notice. So in that type of scenario, the tenant would never, or they're not required to give the tenant any type of notice of the eviction if notice is waived. Now, the Landlord Tenant Act does require a 30-day notice with information relating to whether it can be cured or not. I believe it's 14 days if it's like it can be remedied by repairs or payment of rent. They have to advise that, if they don't remedy the violation in the 14 days, then the rental agreement will be terminated within 30 days. But most rental agreements, I've only seen one rental agreement that did not waive notice since I've been in Memphis Area Legal Services. So most of them will, for certain, waive notice. So that's something, if you are delinquent on your rental payments, that's just something to be mindful of because you never know. And I found that it's generally related to the relationship that the tenant has with the landlord. Not all landlords, but I think that in the case where the tenant does something to upset the landlord, either calling code enforcement and they're already delinquent on their rental payments, it's highly likely that the landlord will take that because they owe the rent. The Landlord Tenant Act does not prohibit the landlord from filing an eviction if rent is owed. So that's just something, that the tenant has to look out for. And I will reiterate that it's important to know what's in the rental agreement to know how to counteract, if you're faced with certain situations when you're dealing with your landlord.
Sure. Thank you for that. Judge Moore, what do you want tenants to know about appearing in court for eviction proceedings?
I think one of the things that we need to acknowledge is that Tennessee does have law, as you mentioned, the Uniform Landlord-Tenant Act, that sets out the rights and obligations of landlords and tenants. It's very specific as to issues that you questioned, notice, waiver of notice, repairs, things like that. And I have found when folk come to court, most landlords are aware of the Landlord-Tenant Act, though they don't know necessarily all of the specifics. And most tenants are not aware of what the rights and obligations are. And as Ms. Ricks indicated, by the time you get to court, it becomes a learning experience. The Landlord-Tenant Act, I always tell tenants and landlords when they come in, is something that if you're a landlord and you're going to have 1 or 100 pieces of property, you need to know what that Landlord-Tenant Act tells you about what you as a landlord can do, have to do within the guidelines of the law. And for the tenants, I spend a lot of time, if you will, when landlords, and especially tenants, come to court, explaining to tenants what rights and obligations are under the Landlord-Tenant Act. Because by the time a tenant gets to court, he or she is so, the word I've been using lately is discombobulated, and that's grandmama's term.
Yeah.
But it gets kind of
We
confusing.
all know what that means,
We know
though.
what that means. And it gets a bit confusing just because by the time, if you will, that a tenant comes to court, it may be his or her first time ever coming to court. Before a landlord may have come to court 2, 3, 4 times or more and is familiar with the process. Most tenants are not familiar with the process when they come to court. Usually the coming to court is because of non-payment of rent. Many tenants don't realize that when you come to court and say, I didn't pay my rent because I lost my job, that isn't going to be a reason under the Landlord-Tenant Act to say, landlord, no, you're not going to proceed with your lawsuit. So education is so important, which is why I am proud that Memphis Area Legal Services has its hands on target when it comes to trying to help those who come to court who've never had experience with coming to court. Because again, it is such a learning experience. And it's not always an experience that we judges can spend a lot of time giving to landlords or tenants, because we're not charged as judges to educate folk completely with what they need to do when it comes to that particular case. And one other thing I will say about that too is that we are a court of equity. So our job is also to at least help folk to get an understanding about the case for which they're coming to court for.
Sure. Thank you. And as a follow-up, based on the things you see in court regularly that you've alluded to, are there elements of the law regarding eviction that landlords and tenants could and should better understand?
The notice requirement. I think that is so very important. There is a section of the Landlord-Tenant Act that says notice of a default. In other words, you haven't paid your rent. And if you haven't paid your rent, then I can immediately go to court and file the eviction process. Or you may have an instance, of course, where that is not in a lease agreement. And I have seen that a number of times. Mr. Warren says only once, but I've seen it a number of times where there is nothing in a lease agreement that says that notice will be waived. And that's generally a lease agreement that's generic. It's something that a landlord may have gotten off the computer that doesn't necessarily comply with the laws of the state of Tennessee. So the notice requirement, I think, is very important, because I've seen tenants who will come to court and say, well, Judge, he didn't give me a 30-day notice. And then, because sometimes, tenants will know that, I'm supposed to get a notice. And so I'll ask for the lease agreement, because I think it's important that whatever the landlord is looking at, I am looking at, the tenant needs to review also. And so I'll ask the landlord, may I see your lease agreement? I look at it. Where is the waiver of notice requirement? It's there. And then I have the tenant look with me. Here, this is what it says, and this is what the law says. So to me, that is probably one of the biggest things, because the tenant wants to know, why am I in court now? I didn't get that notice. And then, of course, you mentioned about repairs and things like that. And I haven't found the repair issue to be as big of a problem, if you will, as the notice issue.
Great, thank you. Ms. Ricks, if you should have a challenge with paying your rent, do you know what resources are available to assist you at this point now?
Now I do, but prior to, no, I did not. Because once again, we were not a family that needed resources. So when you've come from being able to handle yourself, never needing those type of resources, to being in a place where you need them and it's urgent, it's like, where do you go?
Sure. And related to that, Attorney Warren, what rental assistance resources are available?
Okay, you have emergency rental assistance, ERA, at home901.org. You have Community Services Agency, CSA, Catholic Charities, and MIFA may to some extent provide some assistance.
And as a follow-up, if a tenant applies for and is approved for rental assistance through Home 901, does the landlord have to accept payment?
No, it's completely voluntary. So there's no legal requirement for them to cooperate with any third party.
Okay. Attorney Sisman, why might a landlord not want to accept Home 901 payment? And what happens if the landlord does not accept payment?
Well, the simple answer to that is I don't understand why a landlord wouldn't take money from 901 Homes. Those of us who do this all the time have been racking our brains trying to figure out why somebody wouldn't take money that way. But having said that, if the landlord chooses not to participate, then the program will pay the money to the tenant, and then the tenant can use that money to move. And if I can take the advantage to follow up on something Robin said, you're fortunate if you've only seen one lease that didn't have. I see them all the time, and not only is Ms. Ricks not alone in not having read her lease. There are a lot of landlords that I see in my office who haven't read their leases either, and they don't know what notice or waiver of notice means until you point it out to them. So it's not just the tenants who don't know what's in their lease agreement. A lot of landlords don't know what's in their lease agreement either. But there isn't, to be serious about the answer to the question, I've not been able to discern any particular reason why people won't take the 901 Homes money. It seems to be, sometimes it's personal. Sometimes it's,
you mean the relationship? There's
something, some down in the breakdown of the relationship. And sometimes they have something else they want to do with the property, so they want the tenant to move.
I see. Mr. Mathis, what do you consider when evaluating whether to accept rental assistance?
Well, you have to consider your tenant, number one. Did the tenant have a good payment history to begin with? Are they working within the lease? Do they damage your property? All of those type things come into play, your relationship with the landlord itself.
Sure. And as a follow-up, do you consider rental assistance efforts to be mutually beneficial for both tenant and landlord?
Yes, it is mutually beneficial. I think the shortcomings come with language barriers. We have a lot of new landlords, a lot of foreign landlords. So I found a lot of the tenants that don't know, it's language barriers.
And related to that, what do you think could be done to incentivize more landlords to participate in rental assistance programs?
Well, I think the word just needs to get out. I think these cases where landlords do not accept are isolated incidents and not the overall package. There is a real need that I see within Shelby County.
Sure. Judge Moore, what would you like to see landlords and their attorneys consider before declining to accept rental assistance?
I think when we first started the rental assistance program because of COVID, there was quite a bit of pushback, if you will, from accepting the monies. One, the strategies with getting the application process in rather quickly, trying to get the information out to landlords and tenants that this money is available, and then getting eventually the money to the landlords was a slow process. And that was because we had to set up, in accordance with the federal guidelines, how are you going to get this money to the landlords and to the tenants within a reasonable period of time so that it would be beneficial to everyone. And so initially, we all, the courts, the landlords, the tenants, the attorneys, were trying to figure this thing out. How are we going to do this? What are we going to do? And how can we make it work? Once the ball started rolling and we began to make it work, then you had more landlords that were on board and they were understanding the process, could see that there is actually money and it would be coming in. I think a lot of times we are so used to hearing about red tape, federal red tape, government red tape, that I think we all were beginning to think this is going to take so long because there were a lot of people who had need. The tenants were coming in who didn't know about the process because we spent a lot of time trying to get the information out. Once we got that information in, we were able to get it out and get it out more quickly. And so landlords were like, okay, I will accept the money. Tenants were like, I'm going to go and I'm going to apply. And then those powers that be were taking the applications and issuing the monies, knew what they needed to do to make sure that they were following the guidelines and getting the monies issued. The problem began to come in, though. We were getting a lot of applications. And when you have a lot of applications, you got to have the staff to process it. And we never really had a lot of staff in the very beginning to process it. And I think Mr. Warren will agree, we still need more staff to help us process the monies that are remaining. And so all of those things came into play. And you mentioned earlier about why is it that a landlord may not want to accept the money? Though we've gotten a good situation where landlords are either accepting the money, or if they're not accepting the money goes to the tenant so the tenant can move somewhere else. The reason why landlords were not accepting is because one, and I had a lot of those to come through. One, there was all animosity between the landlord and tenant. Landlord like, $10,000? I don't care. I want you gone. It was just so much angst there, if you will. And so the landlord thought, my peace of mind is better than $10,000. And so the part of the program where we could get that money to the tenants then came into play. Or you had a situation where I think it was said that, there may have been damage, the history of being a good or a bad tenant, and the landlord did not want to have to deal with that any further. Or there may have been a situation where something else was going on, like the sale of property. Whatever the situation was then and may very well be now, the process has gotten so much better. And we have more monies, if you will, available than just what we had before, as Mr. Warren mentioned, like CSA, MIFA, Catholic charities, and even churches. Churches stepped up to the plate as best as they could, and they always have and always will, as far as helping tenants who are needful of rent being paid.
Sure. Thank you so much for that thorough response. Attorney Sisman, what rights does a landlord have to remove a tenant who has additional individuals living in the rental property? who are not listed as residents on the lease?
Well, we've made reference to the Landlord-Tenant Act. The Landlord-Tenant Act gives the landlord the opportunity to write a letter to a tenant and say, you're in violation of the lease because you have unauthorized people living. You have 14 days to get those people out of your place. And at the end of 14 days, if they're still there, then the landlord can file an FED.
Do you mind saying what a FED is?
An FED stands for Forcible Entry and Detainer. That's the standard eviction proceeding in Tennessee. It would be easier to just say eviction proceeding, but the statute calls them that. Everything that the Landlord-Tenant Act gives either the landlord or the tenant the right to do is going to end up with either the landlord having to file an eviction or the tenant having to file a lawsuit to enforce their rights under the lease. So if you tell somebody you have 14 days to move those people out or get rid of the dog or whatever, at the end of that 14-day period, you're just going to go down to General Sessions Court and file an eviction proceeding.
Great, thank you. Judge Moore, please walk through what happens when a tenant goes to court for the first time and any subsequent times.
When a tenant's case is called in court because he or she is notified, usually before COVID, the notification, the date to come to court would be given to the landlord and the tenant at the time the paper was served. Now it's just kind of a little bit different because of COVID, because we do have a backlog of cases in our General Sessions Court. Our clerk's office has been setting the cases and then sending notice, a 2-week notice to the landlord and tenant that, hey, your case is now set in court. And either with that notice, the landlord and tenant is given the court that that the case is assigned to, or they come to the courthouse, which is at 140 Adams on that first floor, go to room 106, the clerk's office, and then find out, where am I assigned? In our courts, we have 2 dockets, Monday through Thursday, 10 o'clock docket and a 1:30 docket. And on Friday, we have a 10 o'clock docket. So once the notice is given to come to court, the landlord and tenant comes to the assigned courtroom, and then their case is called by the docket number. If it is the first time that they have come to court, then the court asks several questions. Usually what I do is I want to find out, okay, you're here on an eviction. Is it because you're saying, landlord, that it is non-payment of rent, a default? And if so, how much money are we talking about? And so when the landlord tells me how much money it is, then I talk with the tenant and say, okay, landlord says you owe $3,000 worth of rent. That amount does not add in the court costs, which is what was paid to file the lawsuit and get served. And 9 times out of 10, the defendant here, the tenant, will have to pay the court cost. Usually the landlord is able to give that information to the tenant. If the tenant says, Judge, I agree that I owe, and then they go and talk about payment. But always in our eviction cases, unless there are some other kind of circumstances going on, a judgment, which is where you say you owe the money, also includes the past due rent, the court cost, and then possession of the property. And possession of the property means that the tenant then has 10 days to move before the tenant can be evicted, unless the landlord and tenant make other arrangements. And sometimes the landlord and tenant are able to make arrangements where the tenant will pay and stay. When the first time a tenant comes to court—
Wait a minute, a moment of civility did you just describe?
Not just a moment, it happens more times than you would think.
I'm glad to hear that.
It happens quite a bit. Now, there are times that they're kind of fighting, but we'll talk about that another day.
Okay.
Because that's a long
Robin and I
story.
don't want to be there when that happens.
That's a
I'm
long
just saying.
story. But when the first time that the landlord and tenant come to court, the law gives a little bit of time for the case to come back to court a second time if there is no agreement. And the time period is usually about 14 days. That's what the law says, unless the parties agree that they'll give it a little bit more time. Probably 9 times out of 10, it's that 14 days, and then 10 times out of 10, you'll have a request, Judge, can we just reset it for 1 week? Because the landlord wants that property back or wants a quicker resolution of the matter. But that 14-day window does several things. One is allow the tenant and the landlord an opportunity to read up, study what your rights and obligations are. Because again, they may not always know everything that they need to know, because when the case is reset, it's generally set for a trial where the landlord will tell his side of the story or her side of the story, and then the tenant will have an opportunity to speak also. Or get an attorney if they've come in representing themselves. One thing about our courts, probably a big part of the cases are handled by litigants, landlords, and tenants who represent themselves for whatever reason. Whether they can't afford to hire an attorney, don't want to hire an attorney, or feel that they are capable of handling the case. And I will say that oftentimes my instructions every time is that you have a right to represent yourself, but you have to understand. You have to know the laws, the rules, and the procedures, just like lawyers, and have a good case, but lose it because you don't know what to do. I also tell them that this is not like Judge Judy. She handles cases for entertainment, and I don't make millions of dollars. So you need to know what to do. It's fine that you're going to represent yourself, but know what you're doing, because this is so important to you. And the court wants to give you the opportunity to be heard, but you have to do it within the guidelines of the law. So as I've said, you've got the first time coming to court, possibly a second time. And I'll lastly say that a lot of times, even though a case may be set for the second time, after those 14 days, the parties, the landlord and tenant, may very well come back to court and say, Judge, can we dismiss the case because we've already resolved it? Or you may have a tenant who says, I'll go ahead and pay. Or you may have the parties not showing up at all because they've resolved the case. And guess what? That's okay. Mm-hmm. We don't send the sheriff out to go pick up anybody if they don't show up in court, in General Sessions Court. If they don't come back and they haven't told us that we need to reset it, because we do let people call in and say, Judge, I'm sick, or Judge, I can't make it. And we try to reset cases to accommodate people. But the bottom line is that if you don't come back, we're going to assume that you've resolved it, because people don't want to take off work all the time. They don't want to find that parking that's difficult sometimes downtown. And it's all good. Yeah.
It's very surprising to me, after 45 years of being a lawyer, how many people don't show up. Mm-hmm. And how many times people will say when you ask them, well, you didn't agree, why did you say you agreed? Well, I was scared, or mm-hmm. I was afraid of the judge, or whatever. And there's not anything to be afraid of. It's a process, and you can speak your mind. You're not gonna get in trouble for speaking your mind.
And can I piggyback off what he just said, Absolutely. Which is so true, that oftentimes people come to court, this is their first time coming to court, they're nervous, they're afraid, they see this judge in this black robe and they're like, okay, what should I do? And I spend a lot of time with litigants that come to my courtroom. There are 6 of us judges, and I think we all try really, really hard to make people feel comfortable, to answer any questions, because I will spend time saying, well, do you have any questions? Do you understand? And hope and pray that they do understand, that they don't have any questions, that if they do, they can ask any questions. And sometimes that works, because sometimes I have found that even when you take time with folk, tell them you can ask a question, they still will leave out, still not sure about what happened, and then will come back in and say, well, Judge, I still didn't understand. I'm like, you could ask any questions that you want. And I kind of joke around with them and say, okay. So coming to the courthouse is truly a process on a daily basis. And as judges, we do what we can, and we go the extra mile sometimes, but sometimes even going the extra mile may very well require going 2, 3, 4, 5.
Sure. And you touched on this for this final question, Judge. Each party has certain rights with regards to a continuance in General Sessions Court. What are those rights?
Well, it's as I said earlier about a tenant who comes in and says, this is the first time they've come to court. The landlord is ready to dispose of the case. The tenant says, Judge, I want to go ahead and reset. Now, the tenant may ask for a reset because I have given instructions. Madam Tenant, you have a right to agree, try to make payment arrangements, but understand the pay and stay is between you and the landlord because your landlord may not want you to stay. Once I take this judgment, it includes the money and then possession of the property back to the landlord and that 10 days to move. If you pay every dime of that $3,000 and there is a judgment and your landlord wants you to move, your landlord can still move you. Mm-hmm. So I try to explain that to them too. And so probably half the times at least, the tenant will say, well, I want to reset it for the 14 days. I want to go ahead and reset it for a trial. Because to be honest, either they're going to get an attorney or prepare themselves to have a trial, or they'll use that 14 days to try to get themselves together to move. Yep. But they have that right. And we don't ask them, well, why do you need that? Are you going to have a trial? They are entitled by law, for whatever reason, to get that reset, to do whatever they're going to need to do, and then to come back. And I'll admit that the landlords, most of them, many of them, they don't want to reset it for 14 days. And that's understandable because we're talking about money here. And I think that we heard about how important the finances, if you will, are to landlords because most landlords, the reason why they've got rental property is to pay bills on other rental properties and things like that. So it's so important to both sides. But then we have to weigh that with the right of any party to say, I want to come back to court. One of the other things that I do is I have a guide that I have prepared that when a case is reset for whatever reason, I give it to every tenant, every case that comes through that is reset for trial. And it's guidelines that gives people an idea about what we do in court, some of the laws, the rules and procedures. And I always tell them, take that with you, look at it, get a lawyer would be your first option. But if you find you got to represent yourself, hopefully this will help you. It is not a substitute for getting a lawyer, but at least it's something that is packaged there. It is material that is there that will give you an idea about, ooh, I didn't know about that. Ooh, I may not want to do that. Or I got to really think about this thing. And I guess one other thing that I want to add, that 2-week period gives individuals an opportunity to exchange information. Sometimes tenants want, okay, how did it get to $3,000? Or the tenant may say, I had some receipts. Exchange information. And let's see if the exchange of the information will change amounts that people are more comfortable with, will change ideas about having a trial or going ahead and get moved, or whatever the circumstance may be.
Great. Thank you so much. And thank you all for this rich conversation. I would like to open the floor to see if you have any closing comments. Any comments or reflections from your perspective?
My only comment, since everyone else is quiet right now, and I'm never quiet, is again to thank you all for this opportunity to be on this panel, to have a landlord's perspective, a tenant's perspective, and lawyers that come into my courtroom on a regular basis, and to be honest, make me proud to be in the profession of law. I've got 2 attorneys here who work very hard every day to ensure that the courts run smoothly, that we all do everything that is right within the guidelines of the law, and then throw in a little grace and mercy also, if you will. The main thing that I would also like to say, I guess, is that I'm very happy that even though COVID has come, our city, our legal profession has stepped up to the plate, our landlords and tenants, when it has come to saying, okay, we know everybody got troubles. There's money that's available. And when we got to the point where everybody began to work better, it was great. That was great because we got that money and we did not want to lose it. We wanted to use it. And everybody has stepped up. I agree when my landlord here says that, they're not getting enough information out, and that is so true. We're getting a lot of information out, but not enough. And so I think that this venue will help us hopefully to get additional information out. I would love for our media to step up a little bit when it comes to letting folks know there is still money available, because I'm still getting cases in where people have an enormous amount of money that is owed, $10,000, $9,000, $8,000, and had no idea that 901 existed. And so in my courtroom, there's a stack of information that's available. I give it to them, and then we all go from there. So being the judge, even in COVID, has truly been an experience, because we're not just going to work. We're not just sitting on the bench. We're not just doing what we've been doing all the time. We have had to redo, fix, redo again, and I'm thankful to see that everything is working for the most part.
Sure.
I'd like
Mr.
to
Mathis, please.
Yeah, I'd like to piggyback a little bit off of what she said in question form. Can you explain a little bit more about the contact, how you contact 901 and the expectations behind that, and the connection between 901 Homes and 311?
If you go to the 901 Homes website, it's my understanding, and this is what I've been told, is that landlords can apply just like tenants can. Mm-hmm. And so you have to go to 901 Homes and fill out the forms. I have clients who have reached out to their tenants and helped them walk through the process. I've had site managers who've told me, well, I had so-and-so come in and we filled out the forms together. Mm. And my experience has been that in terms of my somewhat brief interaction with it, is it's pretty seamless. If you give them the information, these things come together pretty quick. They don't hold up. It takes some time for the county to write the checks, but the money, is processed pretty as quickly as the county can do it with the number of people the county has, because they're the ones writing the checks.
The home901.org is what gets you to the federal dollars, the state and local dollars that are combined for your application process. Of course, we mentioned about other agencies that may be separate, like MIFA, Catholic Charities, CSA. Yeah. But right now, that main organization, home901.org, will get you directly to what you need, the information that you need for the application process, how it works, and all of that.
Okay, thank you.
Well, thank you all so much for this discussion. Oh, we can't leave Ms. Ricks out. Ms. Ricks.
Yes, Ms. Ricks.
I just wanted to say, for tenants, learn the law, because that is your protection. So for my family, we learned and we were navigating, and we were blessed to have an attorney who was able to walk us through the process, because we didn't know. And if you talk to me about medical terminology, I've got you, because that's my background. But when it comes down to reading the jargon on your lease, have a lawyer look over it even when you sign it. Get an understanding, because I read my lease. I'm an avid reader. My mother taught me, you don't sign your name on a dotted line unless you read every word. I read the lease. I had an understanding to what I thought it meant, but then there's a difference between what that means in a legal term as opposed to being uneducated and thinking on my level, this is what it means. But when you step into that in a courtroom setting, or when it comes down to honoring your lease, there's a different meaning. And so there's more accountability and responsibility to those things. But when you sign your lease, you never think that you're not going to pay. You don't sign an agreement to house your family and then think that something's going to come up that you're not going to be able to pay your rent, where you're going to be posed with an eviction. So learning the law, educating yourself, what's it called? The Landlord Tenant Act. That's very important. So whoever watches this in the future, whoever you are, Google it. Talk to legal services, talk to lawyers and attorneys, even if you're not in a situation of crisis now, because there were things that came up in my lease that I didn't know. Like my landlord wrote that the lease was late on day 2. So we were there, we paid our rent on the 1st every month because on the 2nd it was late. But by law, it's only supposed to be late on the 5th. So there is a grace period that was not allocated to us. There were things that were in the lease that were illegal according to the Landlord-Tenant Act. But had I would have never known, but we never had a problem. So the only reason why our landlord did not accept payment from the program was because the program didn't pay the late fee. But then their late fee was 15% of the rent, whereas the law allocates for 10% of the rent. And so there were things that were walking and learning advantages that I gained through this process that I would have never known. Because I've always thought, is your property, is your house, whatever you say goes. I'm gonna look at it, and if I can do it, I'm gonna sign my name on it. If I can't, then I'm gonna find somewhere that I feel like I can. And so, but I never knew that law was there. And I never knew that those things were illegal. So educating yourself in this realm is very important for a tenant. So
Can I just add one quick thing, because I think it's important from what Ms. Wick says, because this comes up often in court where tenants have an issue with repairs. There's a hole in the floor. There's a hole in the ceiling. There's leaking. Just all kinds of things that the landlord may very well be responsible for repairing. And tenants don't understand. If they read that Landlord-Tenant Act and try to get an understanding by going either to legal services or speaking with an attorney, and if you can't pay, find one, they will give you at least a free consultation, however that may work nowadays. But don't really understand that there are notice requirements, not just a landlord when it comes to a default, you didn't pay your rent notice, but notice requirements of any repairs that need to be made. The way that things are now, the notice requirement may be a little bit more, at one time it was like written notice, and it still is. But the question is, what kind of notice is there? Because if you just tell your landlord and you come to court and say, I didn't pay my rent because my landlord didn't fix some property, well, we're not the kind of state that lets you withhold rent because your landlord isn't making repairs. There are other actions that a tenant can take when a landlord fails to make necessary repairs. And so tenants need to be aware of that, because that comes to court on a regular basis. And not only that, by the time you get to court and you say, well, I told him a bunch of times, the landlord's like, well, I didn't get it, or I don't know anything about it. But when you have something in writing that maybe you should go to the management office and somebody kind of puts his or her initial on your copy, that most certainly will help when you have to come to court and testify.
Sure.
And I want to add one more thing, piggybacking on what Ms. Rick said. I think that, I know she mentioned something about rent being owed on the 5th. Generally, the way I understand it is that you agree to pay your rent on or before the 1st day of the month, in most cases. Now, in theory, if you don't pay it on the 1st of the month, you are technically in breach of the rental agreement. And it may not come into play unless you are in court or your landlord is upset with you for some reason, and they decide to file an eviction against you, which I have seen done where it was the 2nd day of the month and the tenant had been locked out of the portal. So it's important to pay attention to that language, because a lot of our clients that call us say, well, I have until the 5th. I'm like, no, technically you were in breach after the 1st because you agreed to pay on or before the 1st. So it's important to look for that language, because you don't want to be in a position where if you are in court and let's say you win your case on another issue and it's the 2nd day of the month. And from what I've seen, a lot of landlords' attorneys were like, well, did you pay rent for this month? And they'll say, no, it's not due until the 5th. And then they are evicted because you have breached the rental agreement. So that's just something to look out for, that language.
Thank you all for this rich and important discussion in our community. And we are so proud to host this conversation at the National Civil Rights Museum, where we think about our community, our Memphis community, and our community at large, and making sure that human and civil rights and social justice issues are at the forefront of our society. Thank you so much.
I would like to speak to all the landlords out there, especially the ones here in Shelby County. The 901 program is here for you. It was created for you to save you. Don't fret about the waits or the lack of information. Go to these sites because they're full of information. We're giving you what you need to get what you need out of the program, and it's here to assist. It is important to open up clinics and open up discussions such as these to make the public aware and make tenants aware of their rights and where to go for assistance. That is primarily one of the reasons I'm here today, is to help add to that voice of reason, that voice of solitude.
The resources that have been the most beneficial to me are the Home 901 program, because it helped allocate funds for me to relocate my family, as well as the process. It helped to educate me on the rights for tenants in this going through eviction. You know, educating yourself, knowing your rights, knowing the laws that are there to protect you and to help you.
The law of the state of Tennessee with regard to notice of default is that if you don't have a document that's signed by the tenant that waives notice, you have to give notice. The Landlord-Tenant Act, Tennessee Uniform Residential Landlord-Tenant Act, says that a tenant can waive notice, but only if it's in a written lease. Most leases waive notice. If the lease waives notice, then you don't have to tell the tenant he's behind in the rent. And because I mostly represent landlords, frankly, I think a tenant knows that he hadn't paid the rent, so I can see why you'd want a waiver. If you waive notice, that means you can start your legal proceeding to evict the tenant at an earlier date than if you have to give an additional notice because you don't have a waiver. You know, if I was going to say anything to both sides, because it didn't come out enough on the landlord side, you need to read your documents. You know, you need to read the Landlord-Tenant Act. You need to read the lease agreements that you're relying on. You need to make sure your lease agreement complies with the law of the state of Tennessee. If you're a tenant and you can't pay your rent, talk to your landlord. Communication is important. If you're a landlord and your tenant's not paying you, talk to your tenant. And if you have a problem with the property, always talk to your landlord. Maybe they'll come fix it. Maybe they're not aware of it. A lot of times I've had tenants who have a problem and they'll call it at 7:30 on a Friday night. Hey, something's broken. Well, I can't get anybody out there to fix it till Monday, but you've known about it since yesterday. Talk to your landlord. Talk to your tenant. Communicate.
What I would like landlords and tenants to know about appearing in court is to understand we judges understand. Even though we're sitting on the bench in our black robe, there's no need to be nervous. We know that you're going to be. But our jobs are to be fair and impartial, to hear the proof that's presented, and to hopefully help you to understand the process, which means that when you come to court, there are laws, rules, and procedures that must be followed. And it is our job that you understand that you understand what you need to do so that the court can do what it needs to do also. So that at the end of the day, you're getting what you need, what you want, and the court is satisfied that we've done the job that we are charged with doing.
If you are a tenant who needs some legal assistance, you can contact Memphis Area Legal Services at 901-432-4663. If you are a person looking for rental assistance, please visit home901.org.
Today's panel discussion was brought to you by the Memphis Bar Foundation's 901 Legal Connect. 901 Legal Connect is an online resource designed to increase access to civil legal assistance for the residents of Fayette County, Lauderdale, Shelby, and Tipton counties. Individuals in need of legal assistance can visit 901.legalconnect.org in order to apply for assistance and be connected with one of our 2 legal service providers. Thank you so much for watching.